Today we're going to be looking at an overview of the appellate process that we're going to be looking into more detail in the classes upcoming. And it's interesting at law school, we spend many hours reading hundreds of appellate cases, but we rarely take a step back to understand what are the rules and procedures about bringing an appeal, and more importantly, what are the rules and procedures that govern whether or not an appeal is successful. But I want to start this discussion in thinking about attempting to overturn a wrongful conviction. And when we think about overturning a wrongful conviction, I think what often first comes to mind is a process that's engaged by teams of lawyers working with students, often through Innocence Projects, which we have here at Allard Law and exist throughout the world, where maybe 10 years after a conviction, new evidence is found, new DNA evidence, or we find a certain form of evidence that was used to convict, such as a fingerprint, is actually highly unreliable. A new witness comes forward, and we ask for the case to be reopened. And that's actually usually a process you go through the Minister of Justice. And that is an essential process. And there are many important cases in Innocence Projects today, again, all over the world. But we sometimes forget there's a first line of defense against wrongful convictions, a very direct route to protecting against wrongful convictions, and that is the Appellate Court. You have one right of appeal as an accused person. We know wrongful convictions happen. We know sometimes errors are made at trial, and either the trial needs to be redone, or in rare cases, there needs to be a different verdict entered at the appellate stage. And we give accused people broad jurisdiction to appeal their convictions. There's very few issues that a court of appeal would hear being argued before it and say, I'm sorry, we have no jurisdiction to look at that error. There's a very broad jurisdiction for a court to look at the appellate record and say, is there an error here, and is that error reversible? Did the error potentially cause the wrong result at trial? Now, it's not an easy thing to successfully appeal a conviction. A lot of resources are put into the trial process. In the first many weeks of this course, we've looked at bringing motions, disclosure rules, trying to set up a fair trial, and we put a lot of time and resources into expertise trying to have a fair trial in the first instance. And there are really two things you need to establish on appeal. One is there was some clear error of fact, law, or procedure. And secondly, that error is reversible. One of the most important issues we're going to look at in the upcoming classes is not only demonstrating error, but showing how that was a meaningful error in terms of the result at trial. Now, what we want to do today is just briefly introduce the steps for bringing an appeal. And the first of those steps is filing a notice of appeal. And that process, where you file that notice, depends on the type of your conviction. If you're convicted of a summary offense, your appeal goes from provincial court, where the trial would have been held because it's a summary offense, and the appeal is heard in the British Columbia Supreme Court, where a Supreme Court judge sits as an appellate judge and reviews the record and sees if there was reversible error. And it's an interesting process. You've got a single judge reviewing a conviction entered by a provincial court judge. What we're going to focus on in this part of the course is indictable appeals, where you're convicted of an indictable offense. And remember, that could be in provincial court, it could be in Supreme Court by judge alone, and it could be in Supreme Court by judge and jury. That file goes to the British Columbia Court of Appeal. And they will generally sit 3 judges on that appeal. In rare instances, they'll sit as 5 judges in a 5-judge panel, and that's at the discretion of the Office of the Chief Justice. For instance, one example where an application can be made to sit 5 justices is where one of the parties is going to be asking the Court of Appeal to overturn one of their precedents. You may be bringing an appeal and say, I simply have a BC Court of Appeal case that is completely against me, but I think I can argue based on policy or decisions from other provinces that policy should be changed and there should be a new result in those types of circumstances. Okay, often the court thinks it's a better setting to overturn that, or potentially overturn that precedent, by sitting as a 5-judge panel. But you first have to file your notice of appeal, as I said, either in BC Supreme Court or in the BC Court of Appeal. And that's an essential process because you are notifying the court, and you serve a copy on the Crown, you're notifying them of your intention to bring an appeal. The second stage in this process is a very onerous and expensive one, and that is in creating the record for the reviewing court. Remember, unless there's exceptional circumstances, the Court of Appeal will not be hearing new evidence. Their job is to look at the trial record, and I mean from the first moment counsel appeared on the file to the time there was a conviction entered, and see if there is an error in that process or a reversible error in that process. And that involves having the entire trial record before you. And that's generally put in 2 sets of documents. One is transcripts. That is a transcript of everything said at trial. What counsel said, what the judge said, what the witnesses said. And that will be produced in a copy of transcripts, and generally the tapes are now run in the courtrooms and later on have to be typed up and certified as the official record. And that process, as I mentioned, is an onerous one because you have to recreate everything that was said at trial. If it's a short trial, it may be 1 volume of transcript that is a few hundred pages. Okay? If it's a fairly long trial that went 3 or 4 weeks, you may well have 10 volumes of transcript in thousands of pages. Okay? But there's a second set of documents you then need to make up. A record of the exhibits. We know evidence is entered through witness testimony, but also through various documents, pictures, actual real evidence that may have been found at the scene, forensic evidence that was collected. What you have to do is also create a record of those exhibits and put them in exhibit books. And sometimes those are just directly copied in. If phone records were presented at trial and entered in an exhibit, you put a copy of those phone records in the exhibit book. If something like a physical gun or a physical knife was presented at trial, you would generally have a picture taken of that and entered in as an exhibit. And the key is this then. The Court of Appeal judge will be reading through the transcript of every word said at trial, and every time it says an exhibit was entered and referred to by a witness, you go to the exhibit book and you see what that witness was referring to. So you have now a full appellate record of everything that happened at trial. Okay, and that's the first stage that you need to do. And you know, we've talked about access to justice issues in this course. Trials are incredibly expensive. Appeals can be doubly expensive. And one of the main reasons is having these basic materials produced will at least cost you in the thousands and could be over $10,000 depending on how long the trial was and how many reproductions need to be done of each type of document. But that is the first stage after filing the notice of appeal, is filing the trial record with the court and providing a copy to the Crown. The next stage is, and many of you were involved in this process in your first year moot, now preparing the factums that will be filed with the court. And obviously the first factum to be filed is the appellant's factum. Okay, and the appellant's factum will really have 3 parts to it. The first is a summary of the facts, and it needs to be a fair and complete summary, but it also needs to highlight the particular factual issues that are germane to the errors you're going to be arguing. So you set out an overview of the facts of the case. You then set out the reasons you say the court made certain errors. They could have been procedural errors, they could be legal errors, they could be factual errors, and you need to argue in the second part of your factum why there were certain errors at trial. Then there's a third part to the factum that counsel sometimes don't focus enough on. You need to demonstrate in your factum why those errors were significant. Why did those errors have meaning in terms of the result of trial? Because as we'll look at in this course, it's very possible for a court of appeal to say there were various errors, but we don't think they were significant. We don't think they would have likely changed the result. In other words, those errors didn't cause prejudice to the accused. Okay? And this is a really essential part then of your factum to say there were these errors, and here's why they made a difference in the trial. Here's why the result may have been different without these errors. And you're essentially trying to direct the court towards one of two remedies. The least remedy you'll be seeking is a new trial. That these errors were so significant, the result might have been different. You also can rarely argue that the errors were so significant and had such a huge impact on the trial that the only reasonable remedy would actually be to switch the verdict and enter an acquittal. Okay, but as I've mentioned, that is a very difficult process. But let us not forget, this is the first line of defense against wrongful convictions. Yes, it may have to be addressed by an Innocence Project in 10 or 20 years, but one of the main functions of the appellate courts, particularly when we consider from the criminal law aspect, is to act as a first line of defense against wrongful convictions. Review the record for error, send the case back. If it appears there were serious errors that might have resulted in a different verdict, or if it was the type of case record that never should have resulted in a conviction, possibly enter an acquittal. This is the first line of defense against wrongful conviction. And the accused has one shot. Okay, as we'll come to in a moment, there's no further right of appeal after your first level of an appeal. This is the chance. If this is a wrongful conviction or potentially a wrongful conviction, this is your one chance that is guaranteed in law to have a hearing to have that conviction overturned. Okay, after the appellant's factum is filed with the court registry and provided to Crown Counsel, next Crown Counsel have to provide their factum. And their factum will again have three parts. Their factum will first address any factual issues that weren't addressed significantly or addressed in enough detail in the appellant's factum. Secondly, the respondent's factum will usually set off saying that they disagree that the alleged errors occurred, that they don't agree that there was legal error, factual error, or procedural error, and therefore no new trial or acquittal should be entered. But again, there's a very important third part usually to the respondent's factum, often an alternative argument. Even if there were errors in the record, they couldn't have reasonably changed the result at trials. They're what we'll come to talk of as an allegation that they were harmless errors. And then again, many appeals boil down to, you think a trial that goes over many weeks or months, chances are there may be some error that occurred at some point during that long process. The Court of Appeal is going to analyze whether there were error, but then critically, whether that error or group of errors was so significant as to require the result to be potentially changed or a new trial ordered. Okay? After the factums are filed, the court then will have an opportunity to then review the materials and review both factums, and so when they come into the hearing, okay, they will be a bench that is very educated about what the grounds are. And so at that point, counsel will begin their oral argument, and as we mentioned before, except if there are rare circumstances, this is not a forum where new evidence will be called. That's only in very, very rare cases. Again, the usual point to an appeal is we have a trial record that's been provided to the court, and counsel argue whether or not there was reversible error. And because the court has had time with the materials, very early into argument, they will often have questions for counsel to set out whether there are certain flaws in their argument, to argue whether this was actually an error or just a discretionary decision of a judge, and often focus on what were the implications of these errors, and do they really rise to the point that requires that a remedy be granted? And those appeals will often be argued in a half day, larger cases full day. In very long trials, you may have multiple days of oral argument. Usually at the end of the appeal, the court will reserve. They will not announce a result, and they will take the time that's needed to look through the arguments again, take into account what was said orally, and often many months after the decision, issue a result. In rare cases, they will actually announce the result at the end of the hearing of the argument and actually provide oral reasons for judgment. Also, in rare circumstances, they will announce the result of the appeal and say that their reasons will follow in a few days. But I would say the most common procedure used by the court is to reserve their decision. Okay? Then they will come back in those months and announce their decision, and one of three decisions will be announced. The first will be whether or not the appeal is simply dismissed and the conviction stands. The second basic option for the court is to announce that there is a remedy for this appeal and that the accused will be granted a new trial. It's then up to the Crown whether they actually wish to retry the accused, but the order from the Court of Appeal is not that a different verdict be entered, but the trial be done again. And the conviction is vacated at that point and the legal process starts again with a new trial. The third option we'll get to at the very end of the course is a rare remedy where the court feels that the trial record was so weak it could have never properly supported a conviction, and the court will in rare circumstances enter an acquittal, which becomes essentially a finding that the accused was acquitted at trial, though that finding is made on appeal. Okay, but that is usually the one chance the accused has to overturn what the defense is alleging is an improper conviction. There is no right of a second appeal, with one exception. If you want to go to a higher court, and looking at indictable appeals, their first level appeals to the BC Court of Appeal, if you want to go to the Supreme Court of Canada, you need permission. Okay, they take 1 out of every about 10 cases and you need to make an application. With one exception for criminal cases, which doesn't exist for other forms of cases. If the 3 judges, when they heard your hearing in the Court of Appeal, if 2 judges would have dismissed the appeal, but 1 judge differed on an issue of law and would have allowed the appeal, either granted a new trial or granted an acquittal, that case will automatically have leave to the Supreme Court of Canada. Okay, so if you have a dissent on a point of law, you can, as an accused person, take your case to the Supreme Court of Canada. Outside of that, if you lose 3-0, you need to make an application to the Supreme Court of Canada. Okay, and very briefly, that is a very difficult application. They take only about 1 out of every 10 cases, and what they're looking for is not only a potential injustice in the case you're bringing before them, but one of the keys for the Supreme Court of Canada, does this issue have national significance? Does it affect trials in other jurisdictions? Is this a point of law that different appellate courts are coming to different results on? And is there a need for us to step in and clarify the law in this area? It's not enough to argue in a Supreme Court of Canada application, the result is wrong in this case and my client has been unjustly convicted. That's a part of your application, but a very significant part of your application needs to be, and you need to take this case because it has national significance beyond this individual result. Okay? But those are only appeals where you can demonstrate that national significance in order to get a second chance. Usually you've only got 1 chance. And as I mentioned, on access to justice issues, and we'll finish with this, it's an incredibly expensive process. I've already mentioned the fees you pay to have the materials produced. Well, then you have to have counsel spending literally hundreds of hours reviewing the transcripts, drafting the factum, which is often done in 3, 4, 5, 6, 7 drafts, and then preparing for argument in the Court of Appeal. Retaining an appeal privately, if it's a fairly lengthy trial, I would say the cost could be anywhere from $50,000 to $100,000. There is legal aid for some appeals, and excellent counsel will do appeals on legal aid, but there's very limited funding for those, and many counsel will end up having to contribute many hours to that process. There also is a process that if legal aid turns you down, you can make an application to the court that your case is so important and you will be completely unable to argue it on your own, to ask the court to appoint you a lawyer. But if you are going through a private process, and many people are turned down for legal aid because they have some form of income or some form of assets, it is an incredibly expensive process, which, again, if you think of the cost of someone going to trial and the resources they've had to expend on that, it is going to be particularly difficult to pay the resources for an appeal, but it's absolutely essential. Why? It's the first line of defense against wrongful convictions.